Hello, and welcome to Unpublished Opinions, an Institute for Justice Roundtable podcast, the podcast where IJ attorneys get together and give their unvarnished and unpublished opinions about the law. I'm your host, John Wrench, the Assistant Director of the Center for Judicial Engagement at the Institute for Justice. We're recording this on April 28th, 2026, and I'm joined today by my colleagues Sam Gedge and Kirby West. Sam and Kirby, welcome on the show.
Thanks, John Wrench.
Thanks for having us.
So we're going to start with asking you to put your contrarian hats on. Everyone who kind of touches the legal field, whether it's students or professors or judges or scholars, I think have a lot of assumptions about the law, whether it's cases or doctrines or methodologies or famous legal figures that they probably take for granted. And I wondered if there's any that you might disagree with. And I wanted to give you an opportunity to be a bit iconoclastic and make your case that a common view of one of those things, a case, a doctrine, a justice, anything like that the common view is actually wrong. So this is your chance for a very hot take, and I'm going to ask Kirby to start.
Well, happily for you, John Wrench, my contrarian hat is my favorite hat since I work at the Institute for Justice. I think that said, this is a hot take that is probably shared by many of my colleagues here, and I would guess maybe some listeners to this podcast as well. But I think in the broader popular imagination, the non-delegation doctrine, which is mostly dead, I think we can probably agree, at least not very successful in recent decades, is either not that important or actively, bad, like good riddance to the non-delegation doctrine, I think is a common take. And I think that is for two reasons. One, people see at best that we know, well, I guess maybe I'll back up. And for those who don't know what the non-delegation doctrine is, the non-delegation doctrine is a idea that the various branches of governments should do their own jobs, and the Constitution does not allow them to give their job to somebody else. Specifically, that Congress is not allowed to give its lawmaking power away to another branch of government, the executive branch of government.
That doesn't sound crazy.
It doesn't sound crazy to me either. And I think what people think is, one, this is kind of like a formality. It doesn't matter that much if Congress is making a regulation or the executive branch is making a regulation. Who really cares? Or I think, it might more like a stronger position against the non-delegation doctrine would just be that Congress can't possibly do its job well enough, right? We live in a complicated world. We need experts in the executive branch and the various administrative agencies who understand, different industries better than Congress ever could, and they can react to changing conditions much faster than Congress can. And the problem with that, I think, and the reason that the non-delegation doctrine should be properly appreciated, as it was back, say, in 1935 in the Schechter Poultry case, is because the constitutional structure isn't just a matter of formality, right? That we're going to have these rules and somebody has to make them. So, okay, Congress, you guys are going to make them. I think the structure of the Constitution and how we make laws is very important. That, of course, Congress is actually an elected body, unlike people in administrative agencies who are not elected. But also it something I think that's underappreciated is that when the constitutional structure is operating correctly, it takes an act of each of the three various branches of government to deprive you of your life or liberty or property, and that Congress has to make a law, and then when you violate the law, the executive branch has to enforce it, and then you get to go in front of an Article III court, and the judge gets to determine, or the jury gets to determine whether or not you actually committed an offense. And anytime you have something where Congress is just totally giving away all its power, that's one less check on abuses of deprivation of liberty that we have. And I think that is disconcerting.
Yeah, it's really interesting what you said about formalism, because I think that some of the people who would react negatively to the term formalism are also, for obvious reasons, the people who would probably say that the non-delegation issue isn't really that much of an issue because if you view this as an overly formalistic doctrine, or separation of powers as kind of an accident of history, but it's not necessarily efficient, it's not necessarily practical, and why should we be bound by it? It's very easy to view it as an accident of the original structure of the government, but things change, and we have to adapt to those things, instead of viewing, at least in this context, formalism as a reflection of like actual value judgments, right? Like separation of powers was an actual value judgment, where the framers were looking at history and saying it's actually really bad when you let power be consolidated in one branch, and policing that with formalism just seems like doing constitutional hygiene rather than formalism for its own sake. Sam, do you have any thoughts about this?
I don't. I don't have major thoughts, John Wrench, though it got me thinking. Some of your listeners, perilously few, I'm sure, might not know that recently you assigned me to have a moot court challenging kind of the very existence of judicial review.
I think fate assigned you that role, but
well, you described me, I think, as the bad guy in this mock trial, and perhaps fairly so. But I think the end result is that I as a result, I kind of have persuaded myself that maybe judicial review is not a good thing. At
like
least
in general.
Well, if not in general, then at least under the 1776 Pennsylvania Constitution, which was the moot court you inflicted upon me. But to your point, right, your operating assumption that, of course, the founders were all into separation of powers, and conglomerating power into one body, of course, would be the enemy of liberty. As you know, as the person who created that mock trial scenario. That was kind of the opposite of what the original framers of the Pennsylvania Constitution thought. They entrenched an enormous amount of power in an elected legislature, had a very weak executive, a very weak judiciary, and that's just kind of my reaction to your thoughts.
I will say, having been there for that moot, I don't know that I was fully convinced, but I found it a much more sympathetic position than I did going in. I thought, oh gosh, this is not as clear as I thought. Although I will say the difference between Sam's contrarian take and mine is, I think, in terms of the liberty maximizing effect on practical consequences, like we have many, many hundreds of thousands of pages and of administrative regulations that I think are, hampering people's liberty. Whereas it seems like judicial review typically goes in the other direction, that like the court can't make up new restrictions of liberty, but it can use judicial review to nix some bad
Except that
laws.
robocall case, maybe 7 years ago.
Wow.
Right?
Yeah,
where there
that's
was
a
that
throwback.
statute.
Yes.
Yeah. The statute says, right, like
That's true.
robocalling is illegal. Should we tell the listeners?
Go
There
for
we
it.
go.
Yes,
Okay. They
yes,
need to hear
yes,
this.
yes.
Robocalling is illegal. And they had a carve out. Congress made a carve out for political robocallers, maybe, or government debt collectors. So there was some carve out. And the Supreme Court said, well, yeah, like you're disfavoring everybody who's not a government debt collector and using robocalls. That's obviously unconstitutional. And the solution is to say that nobody can engage in this kind of robocalling. I still don't know how that is possibly enforceable against like the people who were originally carved out of the statute. Like there wasn't a statute before the decision saying that they couldn't make these kinds of robocalls, and presumably there's still not a statute on the book saying they can't do these kinds of robocalls. So like, what's the prosecutor going to point to?
Yeah.
Anyway.
No, that's a really good point.
Yeah.
A good counterpoint.
Unpublished opinions.
It is interesting, Sam's judicial review critique, because it is true that non-delegation doctrines is a pretty attractive concept within, I would say, the mainstream understanding of separation of powers. But I think it is fair to say that at the founding, it's not like everything was crystallized yet. Like, the U.S. Constitution is definitely reflects certain ideas, but they weren't the only ideas in town. And even Montesquieu is writing around that time, not that long before that time, and people usually cite him as the source for a lot of the separation of powers ideas. So it's not like there weren't people like Thomas Paine, who influences the Pennsylvania Constitution, who thought actually it doesn't really make sense to have judges be the protector of liberties. Is that your hot take, or do you think you have a separate?
That was a hot take. I think what made me especially sympathetic to the whole like contrarian Pennsylvania view before we move off of that is the fact that they write this constitution in 1776 that seems to give very little power to judges. And if you go back in time, like literally 2 years before, I think I mentioned this to you a week or so ago, John, literally 2 years before in 1774, the Chief Justice of the Supreme Court of Pennsylvania, a guy named I think William Allen of Allentown fame, he fled the Commonwealth and moved to England and like spent his time writing these very disobliging pamphlets about how bad Pennsylvania and liberty were. And it's like, there's no world in which the framers 2 years later would have been like, yeah, we want like people like that guy to have the final say on our legislation. But my other kind of, it's not so much a contrarian take as a thought I had a couple of weeks ago, because it seems like, what is it, that Smith case is back in the news, the Peyote case from...
Right, the recent
Employment Division.
Right. And the cert grant doesn't actually put Smith directly in the crosshairs, but everyone's talking about, I think kind of like the standard wisdom is like Smith is very bad. And I haven't read Smith since law school, maybe not even then. I was certainly assigned it in law school. I don't know if I read it then. I certainly haven't read it since. But as I was listening to a different podcast, I think, talking about it recently, it got me wondering, like why is the Smith analysis so wrong? Because without having read it again, it doesn't seem that obviously different from the general kind of like speech conduct line that the Supreme Court has adopted in the context of the free speech clause, right? And, like the classic example when it comes to free speech is, you can't have a law, or if you have a law, for example, that says you can't, burn flags with disrespectful intent, you can't denigrate the flag, like that law is going to get really searching scrutiny under the First Amendment because it's targeting the communicative aspect. It's communicating the speech, and the First Amendment protects speech. But by contrast, if you have a law that says you just can't have outdoor fires because we're concerned about forest fires, and someone goes out there in the forest and starts burning American flags, and you get prosecuted under the Don't Start Forest Fires law, that person is also getting punished for burning a flag, but the law is not going to be subject to any kind of, certainly not a searching level of First Amendment review, because it's triggered not by the communicative aspect, but by a non-communicative conduct. And I'm not sure, it's not obvious to me that Smith is inconsistent with that. And again, I should probably read the opinion before I have hot takes on it. But but it's I understood it the Oregon law or whatever kind of said, it's not like you're not allowed to use peyote for religious purposes. It's just like nobody's allowed to use peyote. Nobody's allowed to burn a fire.
No one's allowed to start fires.
Right, yeah. Right. It seems like it's triggered by a non-communicative, non-religious element. So, and in a way that the fire, the no outdoor fire example is triggered by a non-communicative element. So I don't know how different that is from how we view other parts of the First Amendment. I'm sure people have written and said things about this, but that was something that I was mulling over.
I come from a place of equal ignorance on this point, but I do agree. And it seems like even the dangers, right, are maybe that you have unequally applied laws, or in theory this is neutral, but we all know what's going on here.
The Church of but
the Church of Lukumi accounts for that, right? So we have not only I take your point that I don't know that I see the obvious problem. To the extent I see the problem, it seems like the doctrine already has addressed it. But but John, go to bat for the Smith haters.
No, I think there's a problem there. So one observation is the court has had multiple opportunities to try and do something else, and they seem like they don't know what to replace it with, right? So I think Fulton is a good example. You have multiple opinions, and the court is openly, at least some justices on the court are openly asking what exactly would we replace this with? And if he wants to get rid of this test, there has to be a test. So what's that going to be? I think your comparison to First Amendment doctrine is really interesting because it makes me think of the recent decision in Childs, and the court is trying to say, in talking about what the incident, the incidentally burdened speech concept, what it's not. And it's not, whenever there's animus, that gets you, in the First Amendment context, to Church of Lukumi. And in the religious context, there's also animus as a problem. but there's also I think they even use flag burning as an example in that case, as this isn't about the thing, right? This isn't about some speech content. I think why that might not be a perfect fit and why it's still kind of a problem is in that example with flag burning, the flag burning is communicative, but the ban, there's no claim that it can be a burden on it. I mean, I don't know where I'm trying to slice it, but I think that let's take the flag burning case. If it was a different activity, I'm not sure that case would come out the same way. Like, I think that you could have a situation where you get closer to a Smith problem, where it's like the court doesn't value flag burning very much. I mean, they've protected it. They've said that flag burning is protected. Is it what some people have called like a high value activity? Like, I kind of doubt the court thinks that. I wonder what would happen if it was an activity where it was truly neutral and the consequence was you can't do this very valuable speech. I think then it looks more like Smith, like the Smith problems, which is, to the religious person, that activity is extremely valuable. And I guess the question is, like, is that religious activity more like flag burning, or is it more like an extremely, maybe like commonly appreciated thing? Because peyote is easier, and in some ways I'm not surprised that Smith comes out the way it does when you have peyote. But I think a lot of the more recent cases are like, what if it's not peyote, right? Like, what if it's something that mainstream people who are religious, who have mainstream views, what if it's practices that look more like that than peyote? And what if it looks less like flag burning in a free speech context and more something that people, maybe the average person, views as valuable? And I think the court is grappling with that. So I wouldn't be surprised, and I think the cert grant kind of teased this, is I don't think they're going to knock out Smith, because that was an option. It was one of the questions presented. But do they modify Smith where maybe it's a little bit more respectful towards practices? Like, is there more searching scrutiny? I don't know. But I agree that I don't know what the fix is, and I don't think the court does. And I think it is very popular right now to hate on Smith in kind of the same way it was because Smith was Scalia, right? I think that was like hating on Chevron, which I also don't like Chevron. But there are also problems that, like, it's not surprising that the court was trying to construct a doctrine to deal with it. So I don't know where they're going to go. You have any other thoughts about what they might do, or you think it's just a puzzle?
Yeah, I really don't. I think step one's to read Smith. We'll take it from there.
Hopefully, I think the justices will probably start there.
Yeah, hopefully.
We'll see.
Baby steps.
Is it Smith that matters, or our idea of Smith that matters more? We'll see. So the next question I had for you, and this is more related to, I think, the day-to-day work you do and that IJ does. It seems like in public interest litigation in particular, there are issues where either because of a certain case or a certain doctrine or a certain government practice, if you could have some kind of victory over that doctrine or the case or the practice, it might resolve the issue that we care about, like, once and for all, or it seems that way, right? It's like a whack-a-mole, but
there's only one mole.
But it's whack-a-mole where there's only one mole and not a continuous eternal set of moles to whack. And I guess
sort of the opposite of whack-a-mole.
Yeah, and whack-a-mole
is just like the most boring version of the game.
Right, yeah. You hit it once and then it's gone.
Level 1.
I guess it's more like, is it like hitting a nail with a hammer, or is it like whack-a-mole? And though I'm curious about this game where it is one mole whack. Anyway, so my question is, in the kind of run of IJ's litigation and your work, which of those issues seem more like, you're hitting a nail and potentially solving a problem for good, or pretty close to for good? And which of them seems like whack-a-mole, or, any other type of thing where it's not like a victory against this particular bad behavior is going to end the practice, even though it might rein it in, but it's probably just like the nature of our government and our society means that there will always be certain kinds of problems and you will always need public interest litigation to deal with. Kirby, do you want to start?
I started last time. Sam can go first.
Okay. That's a hard question, John. I I don't think it really fits into either of your strained analogies.
Being very contrarian.
Yeah.
Do you have another kind of arcade game that you would like to use? The claw?
No, not the claw. Maybe like laser tag.
Okay.
Anyway, because like, no, like I have a hard time, and Kirby might be able to point to a couple of good examples, but like ordinarily, like there's not going to be like one case that knocks out an entire IJ pillar. In part because the pillars are designed to seek to vindicate like quite broad principles, right? Like, our First Amendment pillar isn't like we want to, overturn X case. I seem to recall like in the early 1900s, there was an association that was called something like, the Association for, Equality on Rail Cars or something. And a very, very good mission, right? In the aftermath of Plessy versus Ferguson. But a very narrow mission. And I feel like it didn't have the oomph of the NAACP, which was kind of like they had a slightly bigger goals in mind. And likewise, we have bigger goals in mind than like overturning one particular precedent, right? Like that's kind of the model of a public interest organization that's sustainable. But at the same time, like I've never kind of had the whack-a-mole feeling, because that just I feel like that kind of like connotes this kind of futility. Like, was it Tantalus or Sisyphus, right? Or pick your arcade game or Greek mythological character.
I haven't played either of those.
Yeah.
You have to push a boulder up the little mountain in an arcade.
Precisely.
Interesting.
But it could be interesting. But I've never really felt like that either. In that, a lot of our cases, maybe the best analogy is bricks in a wall, right? Like our cases are each like bricks in a larger wall, and you win some, you add a brick, you lose some, you don't get to add that brick. Tetris, maybe.
Wreck-It Ralph.
Wreck-It Ralph. Yep. Mm-hmm. So maybe that's the more optimistic way to view it. I mean, it's certainly the case that there are lots of cases that we bring that are like deliberately and self-consciously part of like a broader series of cases, right? Like our occupational speech cases are just one example of that, where it's just like we're bringing similar cases, sometimes even with identical plaintiffs in different jurisdictions, with the goal of either winning everywhere or developing a circuit split and then getting the Supreme Court to weigh in and hopefully win there. And then that issue itself is actually settled once and for all. But then there are other cases that are kind of slightly more one-off that kind of map onto the principles we're seeking to vindicate, but might not themselves have nationwide applicability. And I mean, just to give one example from my own experience, a few years ago, we challenged, Colorado's, system for the private enforcement of campaign finance laws, which was a very unusual system because most states, they have these complicated, reticulated campaign finance statutes saying, what disclaimers you have to put on your ads and how much money you can spend or receive or whatever. Most states say, the enforcement of this is, in the hands of the Attorney General's office or the DA or the Secretary of State or whatever. These, publicly accountable officials who have a duty to, act impartially and honor the Constitution, whether or not they actually fulfill that in practice. And meanwhile, though, Colorado just didn't have any public official enforcing this extremely Baroque scheme. Instead, they just said, well, any person can basically act as a private prosecutor and sue any other person in administrative court, saying that there's been some penny ante violation of the campaign finance law. And this plays out exactly as you'd expect. You just almost every single example of anybody filing these lawsuits are people who don't like what their political opponents are saying. It's completely shambolic exercise. And the end result is that speech gets suppressed, right? Like we talked to people who were like small time candidates who like were trying to like run for like school board in Colorado, and they get dragged into this litigation by these bad actors, and they're, if not bankrupted, like they have to spend a ton of money. They're facing enormous fines. All of it's orchestrated by people who just want to make their life more difficult because they disagree with their politics. And some people just like dropped out of politics altogether. So, and all of which is to say, right, like it's not like every state has that kind of bizarre and terrible regime because it's a bizarre and terrible regime. But we brought that lawsuit and we ultimately prevailed on it. And even though it's not one that we're going to easily be able to transport to 49 other states, I think it kind of well served, a lot of the kind of the interest, the First Amendment values that we see in a lot of our other cases as well.
Mm-hmm.
Kirby?
That makes me think of our like First Amendment retaliation cases a little bit too, in that, we I think are going to and have make differences in the doctrine to make it more to make the doctrine as a whole more protective. of speech against government retaliation, but like governments aren't going to stop retaliating against people, right? Like to Sam's point, governments will think of new and creative ways to violate people's liberty within our areas of work. And maybe that's more of an ongoing wall building / policing the built wall kind of thing. I think in terms of some of our issue areas where there is sort of more of a clean, like we have decisively won this issue, our school choice work is a good example of that, in which we were for decades fighting this fight against use of state constitutional Blaine amendments to attack educational choice programs. Blaine amendments are state constitutional amendments that are born out of a anti-Catholic animus that said you cannot give state funds to sectarian institutions, which was at the time code for Catholic institutions, and was used to try to attack school choice programs whenever they were passed. And between our cases in front of the U.S. Supreme Court in Espinoza and Carson, we really decisively put a nail in the coffin of those lines of attack against educational choice programs. Though there is still work to be done in that area, of course. Like there are people who really, really dislike educational choice programs, and they will think of new ways to challenge them. But in terms of that kind of really big battle and that one really prevalent line of attack, like IJ decisively won that issue, that Blaine amendments violate the free exercise clause. So I think that's one example of that. I think one that's not happened yet, but in my own work that I sort of see as an ultimate goal too of a decisive win would be a dream case of where we could get the U.S. Supreme Court to say that civil forfeiture outside of the historic context of maritime law is unconstitutional. Like that would be another just huge victory, though of course our pillar is not just civil forfeiture, it's property rights. There's going to be other threats to property rights and still much more work for us to do. But I do think there are some cases or some fights where there is sort of this, one case or a pair of cases or, where you could really, you can kind of decisively win one small part of a broader problem.
Yeah. I mean, it seems like both of you kind of landed on a relatively difficult but optimistic view of how it goes, which is that you do make progress, whether it's through, like Sam said, you get a brick and then you don't get to put one, then you get a brick and you don't get to put one, which can be slower, or pairing cases, or these kind of big cases where you win, you get to pull a lever and it dumps a bunch of bricks. I'm not sure what the analogy is, but it seems like it is you experience the litigation as a plodding forwards, and there is real progress, even if it means that the government will kind of have to go back to the drawing board and try and come up with a new way to do a bad thing. Because, there's always been plunder, right? So it's civil forfeiture might be the most recent example of it. But, how many examples do you have that are something like I don't know whose quote it was originally, but what is the government but a large band of robbers? And so you'll have that issue, but, civil forfeiture is one expression of it. And it will have to hopefully not find a new one, but that impulse will always be there. And I guess our litigation will always be there to find out where that impulse, rears its head next. So the last one I have is even more self-reflection that I'm going to ask you to do. What is something, and it can be very broad here, it can be anything law related or connected to your career, a position, whether it's methodological or doctrinal or strategic, that you once had and either abandoned it or become skeptical of or refined it pretty significantly. And that can be at any time during your life. Sam, do you want to start?
I'm going to need to think on that. Do you have an answer, Kirby?
I have
Sam
two,
has never changed his mind about it.
I have two little answers. Actually, one just came to me when you said, or your career, which is, I don't know if any law students or aspiring law students listen to this podcast, but one thing I think that I have changed my view on is the extent to which, everybody else has it all figured out and knows exactly what they're doing all the time, which I think as a young law student, I thought like, oh gosh, I'm still really like muddling through, and these like maybe someday when I'm a real lawyer, I'll have it all figured out and I'll know exactly what I'm doing all the time. And I think like maybe it's a word of encouragement that increasingly as I progress in my career, I think all my colleagues are so smart and capable and everything. But I do think like there's an element of like always learning and figuring things out as you go. There's not an end point at which you sort of have the practice of law or being a constitutional lawyer figured out and then you're all done. It's like just a continuing education as you go. So that's a career related one, maybe. A law related one is I think in law school, I sort of saw textualism as like, this is the way that the answers are clear. And like, that is one of the benefits of textualism as a mode of interpretation, is that the answers are obvious. And, it's right there in the text. You should just read it. And like, we can all look at it and understand what it means. And I still think I'm still sympathetic to textualism as an interpretive process, but I think as the court has become increasingly textualist, like I see more problems with it, and maybe it's like democracy, the worst system except all the other ones, and that there is some like more movement for manipulation than I previously understood there to be. So like understanding what the original public meaning of words are, for instance, like it seems to me now that that's not always an easy inquiry, and like historians disagree, and there's some room for benign and malicious manipulation of the historical record. So I think maybe that's another one, is I don't know that I've changed my mind. I just think it's more complicated than I originally thought.
I'll second that. I'll have my own thing as well. I'm not totally piggybacking, John. Mine are far less impressive than Kirby's. But I think that's right? Because like you see when you like, it always just drives me crazy when you see like courts or advocates looking like quote unquote looking to history to like say, oh, like this X, Y, or Z thing isn't unconstitutional. I think you had this with rental inspections, Sean, and like their history is, oh, well, like we found an ordinance from Topeka, Kansas from like 1870, and they I don't know, said you could hang, draw, and quarter someone for like speaking ill of the mayor. And so then the First Amendment at the time of the 14th Amendment's ratification, you could hang, draw, and quarter people for speaking ill of the mayor.
Like someone did it at some point.
Yeah, exactly. And like that just seems to be like, people used to use this phrase like law office history in a very denigrating way. I mean, we're in a law office and we talk about history. So I guess I might engage in it as well. But like, the idea that when we're coming down to constitutional interpretation, that it would make any sense to look at what lawmakers, I really of any ilk or any level, what lawmakers did like 150 years ago. Like we don't look at what lawmakers today do in trying to determine like what is or isn't constitutional. Like why would we think that the people back then would, have any more kind of moral interpretive weight? So I agree with your skepticism on some of that. I don't do a ton of self-reflection, John. I don't have nothing against it. It's just like, kids and work and,
it shows, Sam. I didn't want to say it, but
indeed. I mean, this is really my therapy session. Well, one thing I have changed is my relationship to different kinds of fonts over my career.
This is going to be excellent.
Just to end on a high note, yep. I feel like when I started, and also formatting justified.
Okay, so like some aesthetic.
Yeah. Well, yeah. I feel like I started with Times New Roman. I believe I started with just left-hand justified, so the jagged right edge. And now I've kind of moved over in certain briefs to, I think I went to like Century. There was a dark period with a little bit of Garamond, some experimentation with Garamond. That was
I do think that Century
regrettable.
Is better than Garamond.
Yes. And then now I've kind of landed for appellate briefs on Century Expanded, which is a slightly crisper version of Century. And now I'm also kind of dipping my toe in the water with equity as well. And also now oftentimes we'll do the right side justified as well, but with auto hyphenation on, so you don't have the big spaces of white. And I'm sure when we talk about this in like 5 years, when next time you make the mistake of having me back on, I'll have some other kind of place I'm at in my journey. So yeah.
Can I say, You've raised a point of real sensitivity for me. I agree. So I prefer both edges justified.
Yes, as do I.
Yeah,
we're amongst friends.
But I will say this is a point of great insecurity for me because all of the IJers who I think very highly of and think are very intelligent, not unlike Mr. Samuel Gedge, have strong opinions on font. And I just do not at all. And so I am always so self-conscious. I try to think, what is the least offensive font that if someone else is reviewing my brief, they're not going to be like, Kirby uses this? I feel like it feels like such a more weighted decision than I ever thought before. And this is actually just came up yesterday where one of our excellent paralegals here at IJ asked me a font related question, and I was almost embarrassed to say I don't really care. Yeah, it's a point of great insecurity. I feel like I'm just like missing something, and I'm like, I guess this looks better. The thing about equity that really I find difficult is if someone else doesn't have it, it creates such a headache.
And it might lead them to believe when they receive your document
that
they don't have
it's a
equity,
mess.
that you're a crazy person.
And the formatting looks weird, and they're like, "Why did you do?" So that's
the same with my Century Expanded. But also that's why whenever I'm sending things to people,
you have to PDF it.
I do it in PDF. If people are on the team and they're working the document, I'm just like, you got to get up to speed and get the Century Expanded equity.
What about though? Okay, if you have local counsel.
I mean, I love local counsel,
yes.
But they only get PDF.
So I typically do, but I have had local counsels who are like, "Can you please send it to me in Word, preferred?"
I guess I've never had anyone ask me to do that. If it were just for them to review, I guess I wouldn't have too much heartburn. But I still remember 8 years ago.
Oh, not to file. Not to file.
Yeah,
No. I would only ever have a filed document in PDF. But I mean, for review.
Yeah.
I've had local counsel ask me to send it in PDF for them to read it and review it.
Oh, that's fair. That's fair. I guess I default to PDF. One, because of the formatting, and two, because it makes it harder for people to try to line edit it.
Yes.
But I guess if someone asked, I would do it. Though perhaps with a warning.
It's happened to me twice for some reason.
Really?
Yes, yeah.
Huh.
So anyway,
you could
there we go.
Send them the document and the link to download the better font.
Yeah. This will be $200 for you to be able to download and see this document as it should be seen.
It is interesting, Kirby, your reaction, I don't care, and that being a strange feeling, because I do wonder how much of it is just genuinely someone enjoys formatting and aesthetics, and how much people view it as if you were a little bit more serious and thoughtful about this, obviously you would have an opinion.
That's my great fear.
That's
my great fear. I mean, I'm not out here using papyrus,
Sure.
I just use the normal ones, but
yeah, which makes it kind of unfortunate, because it's not clear how much of it is just I enjoy this more. This is a personal preference and I enjoy it more, versus you are unevolved and operating on you inherited Times New Roman, and that's why you use it. But there's probably a bit of a misfocus.
I was going to say, I do continue to use Times New Roman in trial courts and district courts primarily. And the reason is that trial courts and district courts, unlike appellate courts, tend to still or oftentimes operate under page limits as opposed to word limits. And Times New Roman is better than the Century ones. I've been told the equity is even better than Times New Roman.
Century is a little bulky.
Yeah, exactly. And also the page limits are why the two-side justified with auto hyphenate is good too, because instead of having just dead white space on the edges and a line with 2 words on it, it gets it all there. You can buy back maybe a half a page at the end of that brief. So
do you have any? I'm just going to ask because I know that you're into this. Do you have any favorite typographical, any books that you've read where you're oh, this person is into it? Because I know that there are some legal writing books.
Yeah, there are, Matthew Butterick. Yes. You should have Andrew Ward on.
Is he the equity guy?
I think he is the equity guy. Yeah. So I don't. In fact, I don't really think I've read any of them. It really is just if I'm reading briefs and I think they look good, I'll kind of figure out what they do.
What's this?
Yeah, exactly. I'm an amateur. And I don't think poorly of people who are less interested in how the quality of their work appears to others.
That's very magnanimous.
Yeah. I appreciate it.
My weird changed thought about something is I think probably related to Kirby's, in that I think I felt the allure of the 1L introduction to, first of all, Scalia is such a good writer, and you're reading cases and you're this is very spicy and it's very compelling, and it reads different than other decisions. And it's very compelling to kind of like reduce down. I think it is kind of reductionistic in a way now, and that's my change of mind, to reduce down a lot of problems to, well, if only judges stayed, quote, stayed in their lane and weren't applying such philosophical interpretations of the law and maybe stuck to something more textualist or history, or using history and tradition to do that. And I think that that's pretty attractive. I mean, Scalia is often cited as one of the greatest writers in the court's history. Holmes is often cited as another of the greatest writers, and they're both kind of in that lane. I think they're both restraint people. And so there's something very attractive about that, because I think that as a law student, it's tempting because it has the guise of being like a serious thinker. Like, well, of course I would prefer this outcome as well, but I have principles, and so judges shouldn't, as a principled person, judges shouldn't reach out and do the thing just because I like it.
The stupid but constitutional stamp.
100%, yes. And he mentioned that multiple times in talks where, Kirby's referencing Justice Scalia saying that he wishes he had a stamp that said stupid but unconstitutional.
Stupid but constitutional.
But constitutional.
Yeah.
Thank you. And it's a very persuasive point, but I think there's this debate that happened in the mid 80s between Justice Scalia and Richard Epstein, and they wrote these papers. And Richard Epstein's is about two kinds of error, and he's responding to Justice Scalia talking about judicial restraint. And I think it is a pretty, for me, it was very convincing, and it was part of me thinking that maybe this was too reductionistic. And Richard Epstein's argument is you could commit type A error by doing too much when it's not your job, but you could just as easily commit type B error by doing too little when it's your job. And so if you don't have a theory of figuring out like when is it a judge's job to, be engaged mm-hmm. to do kind of what Kirby was talking about, which is fill this space where textualism or history tradition leaves you this gap to fill in. You have to figure out in what situations is actually my job to fill that gap. Mm-hmm. And when am I supposed to draw on principles, which freaks people out. But when are you actually supposed to do that? And not doing it would be a violation of your role. Mm-hmm. And so I think that was much more persuasive than this, I think a little bit more of like a black and white, but very safe view that maybe judges should be kind of less involved.
Yeah, and I think you could just as easily have the reverse of, I actually think this is a useful question that I sometimes ask, like when I was interviewing law students to come work for us for the summer. One of my interview questions was sometimes like, what's a case where you liked the outcome, but you thought it was wrong, or you didn't like it, but you thought it was right? Because I do think it's good to have to have a legal philosophy of some kind, but you could just as easily think of it the other way from the Scalia stamp, right? Where it's great, but unconstitutional. And like you might have, I think you need to your point, John, be willing to step in and say like, listen, the goals are laudatory, but you just can't do this.
And that at the Center for Judicial Engagement is what we're all about. So Sam and Kirby, thank you both for being on the show. To our listeners, I hope you enjoyed our conversation. Be sure to tune into our next episode. Maybe not the next one, Sam will have a new font, but at some point in the future, hopefully, we'll see what you've evolved to. Until then, that's just like your unpublished opinion, man.